Namaste friends, welcome back to my channel Advocate Pramod Bhardwaj Speaks. I am Advocate Pramod Kumar Bhardwaj and in today's video we will discuss critical aspects of sending and responding to a legal notice in India. Whether you are sending a notice or have received one, it is vital to understand the legal implications and necessary precautions. A legal notice is a formal intimation to a person or entity before initiating legal proceedings, and any mistake in its drafting or response can have serious consequences. Watch this video till the end to understand how to handle legal notices correctly and protect your rights effectively. A legal notice serves as an official warning before litigation and provides the recipient an opportunity to address the dispute amicably. Common reasons for sending a legal notice include recovery of dues or loan defaults, breach of contract, property disputes, matrimonial issues such as divorce, maintenance or domestic violence, employer-employee conflicts, and consumer complaints. Understanding the correct way to draft and respond to a legal notice is crucial to ensuring a strong legal position. When sending a legal notice, the first step is to clearly define its purpose. The notice should explicitly state the legal grounds on which it is being issued, along with the supporting facts. If it pertains to financial matters, such as loan recovery, it should mention the details of transactions and communications. In property disputes, the specific property details and ownership claims should be outlined. For matrimonial disputes, the issues in contention, such as alimony, child custody, or domestic abuse, should be detailed. However, while providing these details, it is also important to strategically withhold certain information that may be used as leverage during legal proceedings. A well-drafted notice should include a statement indicating that additional facts and evidence will be presented at an appropriate stage. Precision in language is crucial, as every word in the legal notice holds legal weight and cannot be retracted or modified later. The relief or action expected from the recipient should be clearly mentioned. Engaging a competent advocate to draft the notice ensures that it is legally sound and does not contain any statement that could be detrimental in court. Once finalized, the notice should be sent through a proper channel such as registered post, courier, or email with delivery confirmation, and a copy should be retained for future reference. If you have received a legal notice, never ignore it. Some people believe that refusing to accept a notice will prevent legal action, but this is a misconception. A notice sent via registered post or courier is legally presumed to be delivered even if refused. The first step is to carefully read the notice to understand the allegations, the sender's demands, and the legal provisions cited. Identifying whether the claims are legally valid or frivolous will help in deciding the next course of action. Consulting an experienced advocate is highly advisable, as a legal professional can assess whether a response is necessary and, if so, how it should be framed. Many people panic upon receiving a legal notice and rush to respond without strategic planning. However, a hasty and poorly drafted reply can weaken your position. While replying to a legal notice is not always mandatory, it is beneficial in matters involving financial transactions, contracts, or legal obligations. A well-crafted reply can clarify your stand and even deter unnecessary litigation. If you decide to respond, ensure that your reply is legally accurate, professional, and devoid of emotional or irrelevant statements. The response should directly address the points raised in the notice, supported by documentary evidence where applicable. If the allegations are baseless, the response should categorically refute them with appropriate reasoning. Collecting supporting evidence such as contracts, bank statements, email communications, or any such relevant documents is essential, as they strengthen your defense in case of further legal proceedings. There are several misconceptions about legal notices that need to be dispelled. Firstly, a legal notice is not equivalent to a court summons. It is merely a preliminary step before litigation. Receiving a notice does not mean that a case has already been filed against you. Secondly, there is no statutory requirement to respond to a legal notice within the deadline mentioned in it, whether it is 7, 15, or 30 days, unless mandated by a specified legal provision. Many people believe that failure to reply implies acceptance of allegations, but that is not legally accurate. However, a well drafted reply can serve as a strong defense if the matter escalates to court. Seeking the right legal advice is critical when dealing with legal notices. Not all lawyers specialize in every field of law, so choosing an advocate experienced in civil, criminal, matrimonial, or corporate law, depending on the nature of the notice, is essential. Relying on inaccurate legal advice can be detrimental to your case. A legal notice can sometimes be a powerful tool for dispute resolution, and a well drafted notice or response can prevent unnecessary litigation. Mistakes to avoid include disclosing unnecessary details that may weaken your case, admitting liability without legal consultation, or drafting a notice without professional help. Handling a legal notice properly can protect your interests and prevent avoidable legal complications. Whether you are sending or receiving one, always act with caution and seek legal counsel. If you need assistance in drafting or responding to a legal notice, you may please contact me. My WhatsApp and email are available in the video description. If you found this video helpful, don't forget to like, share, and subscribe to my channel. See you in the next video with more legal insights. Until then, take care and stay legally informed.